Hello, my name is Jahangir. By profession, I am a lawyer and I practice my law in Lahore High Court, Lahore. Basically, I am from Lahore. My hometown is Lahore, and most of my cases and clients come from Lahore, and that's why currently I am practicing law in Lahore. But if any client and anyone would like to avail my services from any other city or from any other province all over the Pakistan, then he can contact me and approach me whenever he or she wants to. My contact number is +923244139397 and my office address is house number 14 street number 2 Faruna in Lahore. Before starting over today's topic, I would like to ask all of you to kindly share my content with the people, with other people, with all the people to whom you know and you want to do a good deed with them. Kindly like my content, share my content, and follow my social media accounts and subscribe my channels. So today's topic is all about how an ex party decree in suit for maintenance can be set aside and what remedy is available or what remedies are available to defendant, especially to a man, husband or father when a suit of maintenance is exported against him by his wife. So before talking upon the broad topic upon this broad topic, I would like to tell and explain before all of you the meaning of a maintenance and what actually maintenance is. The simple and basic definition of a maintenance is an act and a way of providing money, basic necessities to your wife, to your children. To your wife, a husband is duty bound to provide basic necessities and subsistence, which includes shelter. Shelter means home, which includes clothing, food, and all the other basic necessities and essential necessities which are necessary for the living of any human being in this world. These are called, these are all come in the term and domain of maintenance. Now, to come up upon our main topic, and for your clearance and for the clearance of all the wives, women, I would feel happy to explain the scope of maintenance also for a very short period of time. So basically, a suit for maintenance is being filed when a husband kicks her woman out of his home, or if a woman or wife takes a separation or start living separately, either at his at her own separate home, or the home of or with or the home of her parents or siblings, or at some other place, and he wouldn't be he wouldn't be given a divorce from her husband, then he is entitled to a maintenance allowance money from his from her husband, as long as she is in marital relationship, or we may say that as long as she is legally wife of him. And maintenance is also granted to to the children of husband and wife if they are living with their mother. Then husband or father is duty bound to provide their children monthly maintenance for their survival, and in order to meet their expenses and daily needs. According to the Pakistani law, uh, son are entitled to get the maintenance from their father as long as they don't become the major, or you may say that they don't attain the age of majority, which is in some countries is 18 years in, and in some countries it is 20 years, and in some countries it is 16 years. But in Pakistan, the age of majority is 18 years, and father is duty bound to pay the maintenance to his daughters till they get married. This is according to the Pakistani law. And if he avoid to give maintenance to his daughters or sons, or to his legal wife, even she is not, or she wouldn't be living with her, then in law a remedy is available to wife and children, that they can file a suit for maintenance in any court of law of the specific locality where she is living, and where she a wrong has been violated. And when a husband, even after filing the suit in in any court of law, avoid to appear in that case, and avoid to, or keeps hiding his whereabouts, then the court, while exercising his its powers, has the power to pronounce a decree and judgment in his, even in his absence, and it is called, and when it happened, then it is called the ex parte decree. It is a final judgment from any trial court or a family judge, which is also called a civil judge in Pakistan. And when this happened, then there would be coming in most of the people's brains a thought that what remedy Allah provides to them, especially to husbands, males, and fathers. As there is a Latin maxim, ubi jus ibi remedium, means where there is a right, there is a remedy. As women have the right upon men, similarly, men too have the right in the law to not be punished unless they are being heard. It is also a settled principle of law that no one would be condemned unheard, and everyone is innocent unless he or she is proved guilty. So, in this sense, and in this uh, case and scenario, a man, husband, or father, or defendant has a right to file an application for setting aside of ex parte decree passed in or pronounced in suit for maintenance in any court in the same court who has pronounced that decree against him to kindly set aside his that judgment, and that he would be given a chance to present his stance and a chance to defend himself. And the section of law, Pakistani law, which deals with it is Section 9 and its subsection 6 of Family Courts Act 1964. Earlier, this law is was used to called as a West Pakistan Family Courts Act 1964, but after amendment, now its name has been modified and mm, changed and substituted with the Family Court Act 1964. So the subsection 6 of section 9 of Family Court Act 1964 deals with it. And along with it, the9 Order 9 Rule 13 of Code of Civil Procedure 1908 provides a remedy to a defendant to file an application to the trial court or the court who has passed the ex parte decree against him to listen him again and decide and determine that whether he would be given a chance again to defend himself or not. So, according to these sections, a defendant file an application to the same court, family court, trial court, and he the thing which is noteworthy and which is very crucial to remember is that, and very important to remember to keep in mind is that when you have to record this remedy, you have to do this within a stipulated period of time, and which is 30 days of the passing of the decree. If someone or defendant comes after the passing and expiry of lapse of these 30 days, then maybe he would be given, and surely he would be given an alternate remedy. But in that case, he would have to go to session court. But when, as far as he filed his application under Section 9 and its further its subsection 6 of Family Courts Act 1964, and whenever he will file this application before the relevant court, then the family judge will deliberate and peruse the case and will decide that whether the summon has been and notices have been had been submitted sent to him or not. If he would be satisfied, or the defendant or his counsel remain successful to satisfy the court that a due process hasn't been observed, or notices or someone hadn't been sent to them, and that he was unaware of the fact that a decree, a suit of maintenance had been filed against him in any court of law, or till the final judgment or decree, which is in this case his ex parte, that he didn't have the complete idea about this fact that an ex parte decree is going to be announced against him. If he satisfy the court regarding this matter, then he can surely avail the remedy and avail this opportunity from the court. Then court may set aside the ex parte decree against him, and he would be given another chance to rejoin the trial proceeding and present his evidence and the accompanied all other supporting with all other supporting documents, whichever whichever would be in his possession. And but if, in case if the court dissatisfied that his stance is wrong, and whether and that he had been given the ample opportunities to appear before the court, and that he had the knowledge of the litigation against him, and till the final moment when ex parte decree was being pronounced, he had been given the notices, last notices, and with the last opportunities as prescribed in Order 5 Rule 20 of CPC, then he would be then his application could be denied and rejected. In that case, then he would have to go to the higher forum, and the higher forum is not the high court of any province or state. And the lawyers who does so, then they commits the major irregularity, because eventually when someone will challenge, even if you win that case in the lower high court, then still whenever you will whenever you will be contested in the Supreme Court of Pakistan, which is a the apex court of Pakistan, then by the plaintiff, then that court will recognize the irregularity, and then you may fail again on simply on this ground that you hadn't availed the opportunity and the remedy of going to the district court. So before approaching to the lower high court directly and invoking the writ under Article 199 of the Constitution of Pakistan 1973, a defendant, after being rejected and denied the relief from the trial court, he would have to go to session court, and when he would go to session court, then there he can make a stance there before the district and session judge. District and session judge is the judge in every district of any locality, or in other words in any big city. So district and session judge then would have to decide that whether the notices are being have been had been sent to the defendant, or that whether in reality he was unaware of the litigation in the family court in reality, or whether he is just making an excuse and uh, just making the false assertions and making his own concocted story, his own made concocted story. If a defendant or his counsel remains successful to prove their stance that due process hadn't been adopted while serving them notices, and that they were completely unaware of the fact of the case, or the status of the case, or the passing of the ex parte decree, then there are chances that the session judge would pronounce the decision in their favor and would set aside the judgment and decree of the subordinate courts, trial court, or family judge, and then they would be given a chance to rejoin the proceeding. But in case if the session judge dissatisfied with their stance and he finds out that the defendant against is lying with the court and just making his own concocted story and trying to uh, manipulate with the proceeding of the court, and that the every effort had been made in order to send him the notices and inform him about the court proceeding, or that under order 5 rule 20 of CPC, the notices had been substituted way of serving them in the notices had been adopted and implemented in letter and spirit, but still he remained failed. Defendant remained failed to join the court proceeding and appear before them before the trial of the court or family judge. Then the session court too can deny their appeal. It is basically called an appeal, and it is filed uh, under section in the light of under section 14 of family court Act 1964. And if it happened, then it doesn't mean that the game ends here. Then in that case, he still would have the choice to go and avail the higher forum, which is obviously the uh, High Court of Lahore. In that case, someone would have to file the and ask your attorney. Let's suppose ask me to file the writ or invoke the writ under Article 199 of the Constitution of Islamic Republic of Pakistan 1973 in the Lahore High Court. In that case, again, the court will peruse the whole record of the and the proceeding of the trial court and then appellant court and will decide that whether the defendant had been given the ample opportunity and to appear before the trial court, or whether there were there were any irregularity by the trial court or not, whether whether or not every effort had been made to send him the court notices in order to ensure his presence in the court or not. If 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 defendant or his attorney counsel remained successful to satisfy the court on this ground, then he may get a relief from the High Court and this High Court. But if court again dissatisfied, then he would be granted the he would be denied the relief. His this writ petition too would be dismissed, and then in that case he would have to go to the last apex court, which is a Supreme Court and which is in Islamabad. Then he would have to go to Islamabad. As far as the case would concern to lower high court, I can file the cases in high court as I am a license holder of high court. And but the main thing is, uh, in a very rare cases, a client has to go or defendant has to go to the Supreme Court, because prior to all this and even on the trial, in the trial court, when you file an application under under section 9 or and of its subsection 6 of Family Courts Act 1964, then you get the relief and a degree of expertise in suit of maintenance has been in most of the cases set aside. But if you don't get by chance and unluckily if you don't get the relief from there, then you can get the and you can surely get the relief from the session court. But even if you don't get the relief from there, then you will go to high court. And in high court, most of the people get the relief. But in case you don't get the relief from the high court, then you can go to the Supreme Court. So basically, the purpose of making this video and sharing all this knowledge and information with all of you is to firstly increase the knowledge and awareness of all of the people who don't know their rights, and secondly to this is my means of telling all of you that if in any case you need my any legal help or want my legal services, then kindly feel free to contact me and don't hesitate to contact me. Uh, my consultancy fees, if you just want to consult upon any matter, then my consultancy fees is Ras 5,000 PKR Pakistani rupees. And if you or any one of you, whether you are a Pakistani citizen or out of Pakistan, want to avail my services regarding litigation, no matter whether it would be a civil litigation, family litigation, and criminal litigation, then I would give you the free advices during fighting your case in any court of law. So this was today's topic, and I hope that all of you would have enjoyed. And I request you in the end of this video, I request all of you to share my video, my content with everyone and to all the people you know, and kindly avail my services. Contact me by contacting me on my number at my number +923244139397, and by personally visiting my home at my which is my office at house number 14, street number 2, Farouk Ganj, Johor, Punjab, Pakistan. The postal code is 54900. So whenever you would feel the need to get or hire any lawyer, then don't forget to remember me. And I assure you that I would try my best to provide you people my with my best services, the relief which you people want to get, and I would try my best to win you the case in any court of law of Pakistan. Thank you so much. There are too many lawyers, but in Pakistan there are very few lawyers who are honest. And I, whatever client I choose, whether they are foreigners or non-foreigners, or citizens or non-citizens of Pakistan, I try my best to provide them the services. Thank you so much. Please remember me whenever you need me in your prayers, and don't forget or hesitate to contact me in case you need any of my help or services. I will come back to you people and talk with you people with some other topic, and after making research and reading upon and studying upon some other topic at some other day. Okay, goodbye. Thank you.